I'm gonna talk that law. Let's get into it. So today I got Georgia on my mind. Shout out to Ray Charles. So today the judge in Georgia dismissed several counts of the indictment against former President Trump, along as I want to say it was along with three other of his co-defendants. So he threw out those charges. He said, "Hey, there's not enough here. Go back to the drawing board. Your work is sloppy, sloppy work." So not only is he accusing Fonnie of messing with a married man, Trump and his team. I mean, because and she had a conflict of interest. He's also saying your work is sloppy. You charge me with crimes that is not sufficient to tell me what I did wrong. So, for example, if I'm walking down the street and someone says I looked at them wrong, I mean, okay, and I get indicted and I'm charged. Looking at somebody wrong is not a crime. So, what else was done besides just to look? Because if it's just looking only, it's no crime there, and it's dismissed. So the judge basically said, like, "Hey, this is sloppy work. Y'all are not giving Trump and his team enough facts in order for them to be able to prepare a proper defense." I mean, when you go to court, you want to know what you did wrong. And if I go to court and they say, "Hey, you was looking at somebody wrong," I mean, that's not enough. If I was looking at somebody wrong and then I had another element, let's say I was looking at them and I shot out lasers out of my eyes like Superman, and it assaulted them. Okay, now I have enough information, so when I go to trial, I'll be able to properly defend myself. But if you only say, "Hey, I'm looking at somebody wrong," it's not enough. So the DA is saying that Trump and his co-defendants illegally solicited Georgia senators and other Georgia officials to violate their oath of office. And I don't think that they did that, but that's what's alleged in the indictment. And we got to keep in mind, indicting someone is easy. We all heard the saying, you can indict a ham sandwich. That's how easy it is to indict someone. It's just one side, the prosecutor go into a room, and then they say, "Hey, by show of hands, who believes that John Smith should be charged?" And they raise their hand, take a vote, and then that person is indicted. And then they go to the next case, and then the next case, and then the next case. So they keep going case by case by case. And all of the cases normally get indicted. I mean, it's just a one-man show. It's no defense attorneys like myself. We're not in the room. We don't get a chance to go in there and say, "Hey, you shouldn't indict my client because of this, this, and this." I mean, it's a one-sided fight. So, of course, if one person's in a room and it's only the prosecutor and they're telling the public, who normally is just regular people, they don't know the law, they're going to believe what the lawyers, the DA tell them. So they're going to vote yes. So the person would normally get indicted. But when you indict someone, it still has to have enough facts in the indictment in order to give the defendant, the person who's being charged, a proper chance to defend themselves. And here, let's go to the order that was released today. Let me see if I can share it with y'all. Present, share screen. So this is the order from this morning, and it's just pretty much an order on defendant special demurrers. And demurrers is just a fancy way of saying there's an objection because the state has failed to state a claim in which relief can be granted. So basically, there's not enough information. They failed to state an actual offense. I mean, they just put a bunch of words together and made it sound fancy, but putting a bunch of words together to make it sound fancy is not the same as actually putting an actual charge together that can actually hold up in court. So the defendants filed a motion against counts 2, 5, 6, 23, 28, and 38. And those counts, let's go down to page 7 to see what the judge actually said of why he throwing those counts out. All right, here we go. Let's start here. And this is the judge reasoning and why some of the charges, were threw out. And he goes on to write, the court's concern is less that the state has failed to allege sufficient conduct of the defendants. In fact, it has alleged in abundance. However, the lack of detail, that's the detail I was talking about, what happened, the lack of detail concerning an essential legal element is, in the judge's opinion, fatal. As written, these 6 counts contain all the essential elements of the crime, but fail to allege sufficient detail regarding the nature of their commission. For example, the underlying felony solicited. So basically, the judge is saying, hey, what is the underlying charge here? I mean, you're saying that they tried to get the Georgia officials to violate their oath, but how? Like, what did they do? I mean, they make a phone call? I mean, that's not enough. And the judge going to say they do not give the defendants enough information to prepare their defenses intelligently, as the defendants could have violated the constitutions and thus the statute in dozens, if not hundreds of distinct ways. So he's saying, hey, there's so many different ways they could have violated the law. It could be dozens, if not hundreds of ways. So you need to tell the defense, how did they violate the law when it comes to counts 2, 5, 6, 23, 28, and 38. And basically what he's saying is they're quashed. I'm throwing them out. You don't have enough here. But he goes on to say, which is very important, you got to always read the small print. He said, this does not mean the entire indictment is dismissed. And then he goes on to say, not only that, the entire indictment is not dismissed, but the state may also seek re-indictment of the 6 counts. So basically what he's doing is he's giving the state another chance to go back and reword it, rewrite it, do whatever you need to do in order for the indictment to be properly formatted. And, they can decide to do that, or they can say, you know what, we don't need those 6 counts. We have so many other counts that we can go forward on. Or they can appeal the judge's decision. They can go straight to the appeals court and say, hey, appeals court, the judge got it wrong. We did everything that we needed to do in the indictment. It is sufficient. It is enough. But it's hard to say. The downside of this, I will say this is a good thing for Trump and his team and the co-defendants, but it's also bad in another way, and I'm going to tell you why. The judge is going to decide this Friday if he should toss the entire case along with the district attorney, toss her entire office off the case. And we all know why. It's been alleged of a conflict of interest occurred between Fonnie Willis and her boyfriend, Nathan Wade, or maybe her ex-boyfriend. I don't even know if they're saying that they still go together. Yes, the young folks word, go together. I don't even know if they're saying that they're still dating. But in any event, the judge is supposed to decide this Friday if he's going to throw out the whole case. The issue with that is what he released today. And my concern is, if he was going to throw out the whole case on Friday, why would he waste his time today writing all these pages, making this big argument, if the whole case was going to go away on Friday? So to me, it would appear that the whole case is not going to go away on Friday. But that doesn't mean that Fonnie Willis and her team won't go away. They may still go away, but the case, it looks like, will stay on the table. And if Fonnie and her team goes away and the case stays on the table, then likely another DA from a neighboring county will come in and look at the case, and then they can pick up the case off the table, and then they can go forward. But I mean, we don't know. You can have, I've seen DAs from a neighboring county, they'll get the case and then they'll look at it and they'll say, that's not enough here. And they move to dismiss the case. So you get the right DA, the neighboring county DA might just throw the case out completely, and that'll be the end of that. Fonnie and her team won't be able to come back and say, hey, no, we want to retry it. No, it's gone. Once that other DA comes in and makes that decision after Fonnie and her team is disqualified. I will say that disqualification is highly likely at this point, simply because it's just been too much going on. It's too many moving pieces. I mean, you have never heard of a story this entertaining with an elected DA getting caught in the bed. Golly, not in the bed, Fonnie. In the bed with a married man. So I think the case will be reassigned to a different prosecutor, but I don't think at this point that the judge is inclined to throw out the case completely. And that kind of makes sense. I mean, just because, two people are dating, that has nothing to do with the actual legal challenge itself. I mean, you can bring in another prosecutor and they can pick up the case, and the case can go forward. Now, will that happen? The case itself, is it a flimsy case? That's debatable. But to me, as a defense attorney, it doesn't appear to be that strong. But as far as Fonnie fighting to stay on the case or re-indicting these 6 counts that was dismissed today, I mean, I can see that happening. She doesn't want this case to go away. I mean, this is a highlight of her career. And somewhere in the back of my mind, I believe that the judge doesn't want the case to go away. Because if the case go away, this is a big case for him too. The camera leaves the courtroom. We probably never see his face again. The publicity is gone. But outside of that, he might be doing the right thing and following the law and keeping the case on the books. But he's been challenged. The judge has been challenged for his seat. It's election time. It's election season. So someone is challenging to take his place to kick him off the case from being the judge. So that will be interesting. I mean, if that happens and you got a new judge come in, who knows where this case may go. Not only is the judge being challenged for his seat, Fonnie Willis is being challenged for her seat. So she might get voted out of office. And if she's voted out of office and a new DA comes in, then, I mean, who knows? So it's a lot of unknowns going on. It's a lot of moving parts at play. And I know that Fonnie and her team wanted the trial to happen before Election Day. But that looks like that's not going to happen. I mean, the judge, even in his order, he gave Fonnie and her team 6 months to either appeal his ruling or correct the indictment and resubmit it back to him, which probably would make sense to do that first. I mean, before I go above the judge's head, I would at least want another chance to fix my mistake, send it back to him, and then see, what he says. And if he's not cooperating, then that's when you appeal it. But I wouldn't jump straight to the appeals court right now because, I mean, it's too early. But in any event, this case is going to be interesting. I mean, it's going to continue to be interesting. And Friday is when it all going to hit the fan. I mean, we're going to know for sure what's really going on as far as if the case is going to go away completely, which I doubt, or if Felony and her team stay on the case or be removed for the appearance of misconduct. It doesn't necessarily have to be misconduct, but even the appearance, even if it looks bad, and this show looked bad. You know, when they friends, both of them had friends that got on the stand and testified against them. So we definitely gonna be back on this camera before Friday. I can tell you that. But before I go, let me remind you, I'm a lawyer, but I'm not your lawyer. I'm only here to talk that law. Well, I guess if the streamer ends, I guess we can get out of here. Let's see.